licensee. She's been a licensee there since September 22nd, 2010, never appeared before the board. The matter of the drugs was her stepson, created havoc in her own household, us here. The place, since she closed it, the secured creditor, Mr. Saperstein, is here. She's consented that the license be turned back over to the secured creditor. In fact, we filed papers with the board, and the license is at the board, not to be reopened until an application has been put in, and then that party would have to meet with the community and with everybody else to get approved.
All right, anything else? All right. We do find by preponderance of the evidence, based on your admission, based on the police reports that are in the file, we do find by preponderance of the evidence a violation of a 4.01A violation on or about April 23rd, 2013, when a minor, Mr. Owens, was indeed served at the establishment. That is, anything else you want to say? And otherwise, we'll just roll through with our decision. Okay, let's go off the record, go to the decision phase. All right, decision phase, November 7th, 2013. Sheila Williams, GNS Williams, LLC, trading as GNS Bar and Lounge, 322 North Franklintown Road. We'll have a panoply of violations here today. The board has received an admission as to 5 charges by the licensee. The board will, by agreement with the parties in their settlement discussions, is dismissing the 4.18 charge of 10/13/2012, the 3.12 charge of 10/13/2012, the 4.18 charge of April 21, 2013, and the 3.12 charge of April 21, 2013. With respect to the other charges, between the admission of the licensee and the corroborating police reports and information, we do find by a preponderance of the evidence guilt of a 4.01A charge occurring on April 23rd by Mr. Owens, purchasing the alcohol while under the age of 21. It's a $500 fine. The 4.16 charge that indeed, based on these police reports, there was a controlled buy at the premises on May 2nd, 2013, and that would violate a use of the premises for the purpose of possession, transfer, or use of a narcotic drug. We find guilt by a preponderance of the evidence there. On the 4.18 charge, no licensee shall allow the commission of basically a crime or anything against public peace, health, safety, and welfare of the community on the premises. The raid also, or the narcotics undercover buy also constitutes a violation of 4.18 on that same date. That's guilty. And then the 4.18 charge from May 10th, 2013 was corroborated by the documents that are now in evidence as the agency's third exhibit, indicate the search and seizure warrant and the confiscation of various drugs and other contraband. That's enough by a preponderance of the evidence to trigger a 4.18 conviction as well. So that we've already fined you $500 on the first offense of the 401A. The charges are very serious. The 4.16 and 4.18 violations, those convictions, indicate a serious failure of administration. In addition to a $125 fine for each of those charges, for an additional $500 in fines, the board will, in fact, order that which most of which you've already done. The premises are ordered immediately closed by the liquor board. The license is indeed ordered immediately returned to Mr. Saperstein, so that you will not be managing the establishment at this time. The board is obviously, Mr. Saperstein, going to look to you in the future to make sure that the next licensee, the next name on the license, is going to be able to give the administration that it needs to the establishment. Are there any questions?
No question.
All right, there'll be a $125 hearing fee for a grand total of $1,125. How soon can we receive payment?
1 week.
1 week? All right, right? Okay, thank you. Thank you all. Mr. Droscher, we're off the record.